next going to talk about the factors. And as Angela pointed out, this was, no one factor is going to be dispositive. All these factors, the board is going to take a holistic view. And over time, we've seen that in some instances, the board values one factor over others. We're going to talk about that to a certain extent. But I'm going to walk through some of these factors just so we can see what are the important considerations that the parties have to address. And the first factor is whether the court granted a stay or evidence exists that one may be granted. So oftentimes the parties have not either requested a stay or are waiting to request a stay until the board issues its institution decision. After Fintiv was made precedential, the board would often look to Fintiv factor 1 as almost counting against the petitioner based on the stay statistics of certain district courts. So we know that a lot of district court, there's a lot of cases in the Western District of Texas and Eastern District of Texas, and they don't have the best, let's say, stats for granting stays. And so that would sometimes count against the petitioner. Now, what the board has done, though, over time is they've often find that this factor is neutral. The only time that it counts against either party is if there is specific evidence indicating how the board would rule. So if the district court, for example, would say, I am not going to grant a stay, I don't care what you do, that's going to probably count against the petitioner. Now, if the district court will indicate that if the board is going to, if the board institutes, I will grant a stay, that will count in favor of the petitioner. So the second factor is dealing with the proximity of the court's trial date. And this is really, this has became quite controversial because as Angela pointed out, so many trial dates move, right? And that happened in NHK. In fact, it happened to Fintiv. I should point out that the Fintiv case that this all comes from, it still has not gone to trial. So this happened in March of 2020, and we're still waiting for that trial. What the board has done is they've looked at the scheduled trial date, and in the board's defense, that's really kind of all they can look at is what is the scheduled trial date. Now, there's been a softening of the board's approach to this, given the fact that so many trial dates move. The third factor is investment in the parallel proceeding. And we've gotten some guidance from the board on factor 3. And this is not just a total amount of investment. This has, if you look it's a San Revolution case we're going to talk about in a little bit, but that has to do with investment in the invalidity issues. So things like 101, things like venue, those don't always count as investment in the invalidity issues. What counts for investment is the party's briefing with respect to dispositive motions on invalidity and the invalidity contentions. Number 4 is also a very big issue, and that has to do with overlap. One of the overarching concerns is that you might have inconsistent results. There's this, the boogeyman is that somehow the board would find a claim to be unpatentable when the district court would find that same claim to be not unpatentable. And there's that overarching concern. The fifth factor is just the identity of the parties. The underlying premise behind Fintiv is that the petitioner really shouldn't get multiple bites at the apple. So you can't get an argument for invalidity before the district court and then present another argument again before the PTAB. And the sixth factor is really kind of a catch-all. I think it's significant that the merits is included in a catch-all. That's what the board should be considering at the outset. But anyway, that's there. It's the merits. And that often is found to be neutral unless there's a very strong, unless there's strong grounds presented by the petitioner.